Okay. Good morning. Good morning. Welcome back. Welcome back. Okay, we'll get started momentarily. What am I forgetting to do? I'm trying to remember. I've shared the screen. Good morning, Shmuel. Yeah, no, I'm glad. I've missed the class. I've missed the shir. Okay, and then my thinking is we're getting close to the end. I mean, it's probably going to take another few months before we finish the Sefer, but I have an idea that I've never studied Talmud Yerushalmi. And so in another 2 weeks, they're starting up the cycle again. So we won't make the beginning of the cycle, but it's something that I'm thinking about very seriously. But I'll keep you posted.
What's different?
It's like asking, what's the difference between Chinese food and Japanese food? It's
really
total.
Chinese and Polish.
Well, they're in the same continent, but I've studied section. I mean, we did Shkolim together in the Daf Yomi cycle. Shkolim is Yerushalmi. So the commentaries are more difficult and the language is more difficult. But once you get past the language, you have to also become you have the language and also the cadence of the Gemara because it's more fragmentary. I think there's a lot more that was lost over the centuries in the Yerushalmi than there was in the Bavli because it wasn't studied as much. So you have to. Yeah, I think so. I mean, I think it would be a real eye opener. I think not. But it wouldn't be as fast. I think it would be just an Amud a day instead of a blot a day. Anyway, we'll see. I have to learn more about it, and we'll figure it out. Okay, so good morning. So welcome, Warren. Okay, so let's take a look at. Thank you. Can't wait to go back. Siman Yud Gimel, Sif Gimel. We're learning about the laws of testimony. This is actually a very practical halachic issue. You're called Yisrael Hayodea Edus Logoi Sheyesh Lo Dinim Yisrael Be'erka Oseihem. So you are you have a non-Jewish person, either that you're friends with or a non-Jewish company, and you're called to testify on behalf of the non-Jewish entity against a Jew, and this is in a secular court. So the question is, are you allowed to testify against a fellow Jew, knowing that your testimony is going to either incriminate him or make him liable? Okay, im yigrom be'eduso l'chayiv ha'Yisrael yoter mima shehaya chayav b'dinei Yisrael asur laha'ido. So, if the secular court, if the opponent of the Jew prevails, will end up causing more loss to the Jew than what he would lose if he went to Beis Din, right? In other words, let's say the Jew is guilty, but instead of them making him just pay what he owes, the secular court is going to apply punitive damages and is going to maybe even incarcerate him and do other things to him that would be above and beyond what he would be held liable for in Beis Din. So then you're not allowed to testify on behalf of the non-Jewish entity. Now, wait for it. In other words, we're going to have to look at some commentaries in order to get some clarity on this issue. But v'im lav mutar laha'ido. But if the penalty that the secular court would impose upon the Jew would be comparable to what he would have to pay if he went to Beis Din against a Jewish opponent, So then it is permissible to testify against them. Look, unfortunately, we know not all Jews are tzaddikim. Not all Jews are honest in business. And sometimes you may be in a situation where you're called to testify against a member of your tribe who has done something unscrupulous. So the Rav Shulchan Aruch says that this is the litmus test. If he's getting what he deserves based on Jewish law, and he would be imposed, the same would be imposed in a secular court, absolutely permissible to testify against him and do whatever you need to do in order to achieve justice for the non-Jew. But if they're going to throw more at him than what he deserves, so then you would not be allowed to testify on behalf of the non-Jew. Ve'im mitchila yichado hagoy liyisrael lihiyot lo aid, he says, if, however, the non-Jew had specified that the Jew is going to be a witness in a transaction. In other words, let's say this is a long-standing business arrangement between the Jew and the non-Jew, and you were involved in this as a potential witness in the entire transaction going back to the genesis of the transaction. And then the Jew, for whatever reason, defaults or reneges or things go mechula. You know how things can sometimes go sideways. And then the Gentile says, now you got to come. So he says, now, if I don't go testify on behalf of the Gentile, so there's going to be a chilul Hashem, right? Because he's going to say, oh, you're just trying to cover up for your tribesmen. Im lo yoid lo, yelech v'yoid lo b'chol inyan. So then you should testify on behalf of the non-Jew in all circumstances, even if the Jew will be penalized at a higher level than what he would be penalized if it was a Beis Din. So, no, if there's no chilul Hashem, and you see that they're going to throw the book at him, so you should not testify. If, however, you feel that there is going to be a chilul Hashem by your not testifying, so then you should testify in all situations. Now, I'm thinking of the worst case scenario. I'm thinking of the worst case scenario where this could potentially be very dangerous, this halacha. What if you know that a Jew is a pedophile? So is this monetary, is there anything? You know a Jew is a pedophile. If the guy was taken to a Beis Din, well, what's the penalty in Beis Din for pedophilia? You're assuming it's a girl. The truth of the matter is that there is no financial penalty for pedophilia in the Jewish in the books, because it's such a perversion. But unfortunately, we know what has gone on, and there may be some Jews who look at this source and they say, well, if I testify against him in court, they're going to make him sit in jail for a certain amount of time. They're going to put him on a national registry. He'll become a pariah to society. It's not what the Beis Din would do to him. So what right do I have to testify against him? So I just want to say at the outset that this halacha does not apply to pedophiles. You know someone's a pedophile, you go immediately to the authorities and you testify against them in a court and have them throw the book at him and have him sit for as long as he needs to sit. No, it's not the only example. I'm giving you, to me, what would be like the most extreme example of where I don't feel that we could properly apply this halacha. So, like Warren said, maybe it's only talking about financial halacha. Let's take a look now and see what the Imrei Yaakov says. Right. Right. So you have to always, you have to obey the law. You have to obey Dina de Malchus Dina. You have to obey the law. So you'd have no choice. You'd have no choice, and you wouldn't be allowed to lie. Right.
we always talk about how the base would come up usually in a monotone case with a compound.
Yeah, well, there's no way to know exactly what the Beis Din would impose. But let's say there's something like maybe the Beis Din, sometimes a Beis Din does impose punitive damages as well. You should know that it is within the jurisdiction of a Beis Din to impose punitive damages. So that's really, I believe, my heart tells me that the Rav Shulchan Aruch is writing for a readership where the secular court was a scary place for a Jew because of overt anti-Semitism, where they would throw the book at the Jew, okay, unjustly. And there, even if you know the Jew is guilty, you shouldn't go testify if you know that they're going to make his life an absolute living hell. When if it was done in Beis Din, he would get, the penalty would be more moderate.
The Jew's existence in the criminal justice system after the verdict is not very promising.
Right. Okay. So
for the Beis Din to pass it to a secular court, instead they get a case like this and say, well, we cannot bring punishment. Can they use
there are cases of criminal activity where the Beis Din will simply say, we're not hearing this case. Yeah, if it's criminal activity, which involves violence and involves sexual crimes or crimes of violence, then the Beis Din will be the first to say, report this to the authorities and have the authorities deal with it.
You know that your next door neighbor is white. You know for a fact.
You are obligated to go to the authorities. Absolutely, al pi halacha, you're obligated to go to the authorities. And if you don't, you have violated the Torah law of lo samad al dam re'echa. Do not stand over your brother's blood or over your fellow's blood. Her blood is on your hands if you don't go to the authorities. I would tell you not even try with the rabbi. Someone came to me and told me that, so I immediately go. Early on, I had a case here where someone was on their block. A guy was selling drugs on their block, and people would come in 2, 3 in the morning, very unsavory characters. And they said, I don't know, should I call the police? I don't want to be a moiser, right? I said, what are you even asking the question? Guy's committing illegal activity. He's ruining the neighborhood. Of course, you call the police. Have the police deal with it immediately. The guy should be hauled off and put in prison. We learned the laws of Masira a long time ago in this context, and we came to the conclusion that in most instances, the laws that prohibit Masira do not apply. And while there are other rabbis who may be more stringent on this issue than others, as far as saying that you shouldn't be Moser, in almost all cases, there's no prohibition of Masira. Okay? Now, so let's take a look at the Imrei Yaakov. There's not a lot of commentary. Asr leha'ido, you're not allowed to testify in secular court. Ve'im heyid mishamtim osalamid yom. If you do testify in secular court at the Jew's expense, where he gets a much harsher punishment than what he would have gotten in Beis Din, so then you, the person who testified, would get put under a ban for 30 days. You'd be on the outs in the Jewish community. And you even, it's a form, would be considered to be a form of tshuva for you to pay the financial loss that you caused the Jew above and beyond what he would normally have had to pay. And so he uses it a language of, if you want to, we allow you to pay. It's not that you're obligated to pay, but it's considered to be an act of piety. V'im lav muter leha'ido, but if it's the courts are not going to impose a harsher penalty, then you are permitted to testify for the Gentile. Dafka lenachri, aval Yisrael hatoveya liyisrael asr lahoid afilu b'makom shedineim kedin Yisrael mishum asher tasim lifneihem v'lo lifnei kusim. This is a very interesting halacha. What if 2 Jews go to court against each other and they refuse to go to Beis Din? And now one of the Jews says, will you come and testify for me in secular court? You have an obligation to tell him, no, I'm not testifying for you. You got to take this to Beis Din. You don't take this to base, then I'm not coming to court on your behalf. You're not allowed to aid and abet someone who is violating the halacha of going to a din Torah before they go to arkaot, before they go to secular court. And that law applies today as well. If the other party refuses to go to Beis Din, so then you have no choice, right? Let's say your friend, you know testimony for your friend that he is owed money. He sends a hazmana to the other Jew, come to Beis Din. The guy refuses. So the Beis Din then will give permission to the plaintiff to go to arkaos, in which case then once the permission is granted, so then you have permission to testify for him.
I mean, they have heard of it, they have no clue, or something never heard of it. So, are you still obligated to do a little kiyuma? Like explain what it is.
You should try. I mean, if you have you're talking about a secular Jew,
If you enough from Jew, and then the from Jew would like to deal with it with Beis Din, but the secular Jew is very foreign to him.
Well, it's not so foreign because really it's really an arbitration panel. I mean, there are arbitration panels that exist in the secular world as well. A lot of times the courts will even recommend arbitration because the docket is too overbooked and they can't hear cases. There are a lot of retired judges that do this for a living. They will set up an arbitration situation where they will preside over a case where the two parties voluntarily submit to binding arbitration. It's different from mediation, it's arbitration, where basically they say, listen, we could wait 6 months or a year or 2 years and go to court and incur great legal expenses, or we can go to this private judge who's retired. He has a good name, a good reputation, that he knows the system, and we can go to him. He'll see us in 3 weeks. And we won't have to pay all of the additional costs. We'll just pay the lawyer's fees, and we'll hear the case before him. A lot of times it's very advantageous. So that's one way of explaining it, is that let's go to an arbitration panel. And if the guy says, no, I want my day in court, then you have no choice, right? It's possible. It's possible that he will, but you try. Ron was asking, should you try? So then the answer is yes, you should try. I remember reading years ago, this is going back over 25 years, there was a Wall Street Journal article about a litigation. I remember who was the plaintiff. It was the defendant between a corporation, a non-Jewish corporation, and an Orthodox Jew. And the Orthodox Jew says, why don't we go to Beit Din and settle our differences? And they agreed. And they wrote about how satisfied they were with the proceedings. Yeah, it was very good publicity. It was in the Wall Street Journal. Now, that's not to say it always works out that way, right? But
does the rabbi know kind of the proportion of secular Jews who go to the Beis Din?
But it's only if it's a secular Jew and an Orthodox Jew. Unfortunately, and I'm sad to report this, but I know of Orthodox Jews who sue each other in secular court. They purport to live by the laws of our Torah, but business is business. Yeah. Yeah, Beis Din won't hear a case once you've gone to Arcos. Beis Din is not required to. Beis Din generally will not allow it. They generally won't allow it. If a guy loses in secular court, I was part of a din Torah many years ago, where we were the defendant. We were trustees on an estate, and we were being sued by a Jewish entity, a Jewish charity, which had produced promissory notes claiming that they were the true beneficiaries of the estate when we believed differently. And so we said to them, so sue us, but sue us in Beis Din. And this very Orthodox charity said, no, we're going to sue you in secular court. And so they started proceedings in secular court. They saw that their case was going poorly. They said, we want to do the right thing. Let's go to Beis Din. So the truth is, halachically, we were in a position to say no to them. We had every right. We as the trustees. I was a trustee. I was not. There was no Beis Din yet. But we felt that would make a chilul Hashem, because then we knew that they were going to take the pious route and say, "Oh, we wanted to go to Beis Din and they didn't let us." So we said, "Okay, we'll all withdraw with prejudice," I think is the term you use, right? That we withdraw our case from the secular court, and we will go to have it heard in Beis Din.
It's only because the verdict had been rendered yet, which is from bad.
That's correct.
So what happened?
We prevailed in Beis Din, and Beis Din even imposed punitive damages on the other party because it involved the production of fraudulent promissory notes. So sometimes people say, "Rabbi, why are you so cynical?" And I say, "You see this gray hair? I had it long before I came to Toronto, but I love all Jews, and you have to love all Jews, right? But it doesn't mean that all Jews, it doesn't matter." And I want to remind you this, it doesn't matter what they look like, what color their yarmulke is, what color their coat or their shirt is, makes absolutely no difference. Makes no difference in the world. You'd judge a human being by their behavior, what comes out of their mouth and what they do. Don't judge people by what they're wearing. A lot of times it's a wolf in sheep's clothing. Okay. Yeah. Okay. How did we get started on this? Okay. So we were talking about going to secular court. Okay. V'im lav muter laha'ido. And so we just learned this halacha that if two Jews are going to secular court, you have to refuse to testify, right? Two from Yidden go to secular court. You say, "You want me to come to secular court and testify on your behalf? Ashan den acherpa. How do you expect me to do that? I'm not going to support what you're doing. Why didn't you go to Beis Din?" "Well, those rabbis, they're all corrupt." Excuse me. Maybe you may have had a negative experience, but what right did you have? You should have taken him to a different Beis Din. So you should have done a zabla. Remember we learned about that term zabla? Ze boer lo echad, v'ze boer lo echad. You can create an ad hoc Beis Din of rabbis that you feel are more trustworthy. Each one picks one, and the two rabbis choose the third. If you feel that the established Beis Din is not going to give you a fair hearing. But there are many ways to set up a Beis Din, even when you feel that you don't trust the let's say what's the word I'm looking for? The establishment, yeah. Okay, the chilul Hashem is if you have to testify in a secular court if you'll create a chilul Hashem, when it's a case between a Jew and a non-Jew. He says, "V'hu adin im ha'akum argishim shah Yisrael yodeya b'davar v'ika lebemechash lebitul kiyum shel Yehudim meilo lechatchila." So the example that the Rav Shulchan Aruch had given was in a case where you were part of the initial transaction, and so the Gentile has made you sort of built in as a witness to the entire affair. Let's say that wasn't the case, but the Gentile still feels that you know what's going on. In other words, he is able to ascertain that you as a Jew were witness to whatever was going on, to the theft or to the illicit activity of the Jew, and you're just refraining because you want to cover up. If you see that, that's also a chilul Hashem, and because that could have negative repercussions also for the future of doing business with Jews in general in the community. And so you really have to assess the situation carefully. You just see it's interesting. I would have expected some likutim over here, but that's it. That's all we got. Yeah. I'm a little disappointed. Maybe we got to poke around a little bit more in some of the other swarm. Okay. Let's go on to the next halacha. I'm just looking at the the footnotes. Oh, okay. So in footnote 34, it's very interesting. In footnote Lamed Daled, he says, I refer you to the Pischei Tshuva on this idea that if a person testifies in secular court in a case where he's going to cause the Jew to lose more than he would have lost in Beis Din, we would put the guy into cherem for 30 days. That was the practice. So the question that is asked in the name of the Birkei Yosef, Shehiksha Amai Mishamtin Oso. Why should we put him in cherem? Leimahai, Eid Ani Be'emes Hi Adati. So let the witness, the Jew, say, what right do you have to castigate or ostracize me? I just testified the truth. The Hay Yisrael Chayev L'Nochri, that this Jew owes the Gentile the money. He says, I know that if this guy would have, if he would have come to a Beis Din, a Jewish Beis Din, and he wouldn't take an oath, the Beis Din would make him pay. But he says he could have gotten out of paying if he would have gone to Beis Din, because the Beis Din would have made him take an oath. And if he would have swore, even maybe swearing falsely, he could have gotten out of paying. So why are you holding me responsible because the secular court made him pay? He deserved to pay. And so the question is being asked, the Jew, if he would have gone to Beis Din, could have figured out a way to not pay the Gentile what he owed him, because he could have taken a false oath. So the Jew says, well, why would I want, how can you make someone, just because someone could have taken a false oath and exempted themselves from paying, why should you take that out on me? I just testified to the truth. Behave b'shem maharitats siman kuf bei shapirish bazeh the kevin shahatorah lo haminaso ve'eno mechayev el shvua yaniach lo lishava l'sheker ve'en lo lihischakim al boro ayin sham. It's a very disturbing response. He basically says that there are opinions that say that if the Jew could have wiggled his way out had he gone to the Beis Din route, even though I know that he actually owes the money, I should still refrain from testifying against him. But that's not generally the way we would go today. It would probably be viewed as a chilul Hashem, and that's why the Rav Shulchan Aruch says at the end, if there's any chilul Hashem involved, so then you have to testify. There's no chachmas to make. All right.
Rabbi, if he gets subpoenaed, don't you have to show up in the secular court? You have no choice.
Yes, that was asked by someone before. If you get subpoenaed, you have to obey the law of the land. Yes, absolutely. Bottom line is that there are very limited applications to this halacha. Okay, in most situations, if you know that a Jew is guilty and he owes money, and you are called upon to testify against the Jew, so first of all, in most situations, the court will probably assess what he would have to pay in Beis Din anyway. So therefore, there's no problem for you to testify. If you feel that he's not going to get a fair hearing, if you really do believe, and it is possible even today, that a judge may have it out for this guy because he's Jewish. It's possible in Canada. It's not unheard of. I want us to be very clear on that. If you feel that that's the case, so then under limited circumstances, you might be able to evade going to court, okay? But know that this has very limited application.
Only answer the questions they ask. Don't give any extra.
It's very difficult to do that when you have lawyers on both sides, because they're going to pump you as much as they can. And once you're in the chair already, things are going to come out. Okay, so let's go on to Sif Daled. Kol zman shezocher hadavar yachol lahoyd laolam. That it doesn't matter how old the case is, as long as you remember, you're still kosher to testify. Something could have happened 15 years ago, and your friend says, "You remember that transaction I made with that guy? Remember he owed me that money 15 years ago? Well, it's come due. He still hasn't paid it. I want to collect." So if you remember, there's no statute of limitations on court cases in halacha. And if a guy asks you to testify, as long as you remember, you're allowed to testify. Now, at our age, we start to forget things. This is the problem, right? So ve'eno choshe shema mitoch shenit yashen hadavar harbe eno zochro al burio. You don't have to be concerned that since it happened so long ago, maybe you don't remember it clearly. Va'afilu im eno nizkar la'edus ela mitoch haksav. So as long as you remember, you're allowed to testify, even though it could be that some of the details may be a little fuzzy, but you definitely distinctly remember. Now, even if you only jog your memory through looking at something that's written down, right? You have to, let me just review the documents again, because I remember there was a transaction, but I don't remember the details. Let me look over the paperwork. You pull up the file. Oh, yeah, that's right. Now I remember. Okay, that's also grounds for you to testify, even if you had to jog your memory based on documentation. We'll continue Amir Tzashem